it does require a lot of flexibility.
Carlo, do you have, in your practice, do you find that there are tight time limitations imposed?
Well, that's certainly the case when you have, it really depends on how many witnesses and experts you have and how many days are allocated for the hearing. I see that parties increasingly agree on a relatively detailed time schedule for the hearing, so there is not really much debate as to whether that was enough or not, because that was pre-agreed by the parties. And once you know that you have 1 hour and you have accepted that and agreed that with the other side, it's difficult to then have more time. But going back to the point and the question you asked about how do you control, so to say, the answer from the witness, I believe it's very difficult to draw the line between not allowing the expert or the witness to say what he or she wants to say, so that the tribunal may think that he's saying something or she's saying something that you don't want to hear, as opposed to, I simply do not have time to hear all what you have to say. So I think saying in advance, well, unfortunately, we have a limited amount of time, so we need to address certain points, and that's why I would ask you to please answer with short answer to my questions, so that everybody knows that you're doing that not because you don't want to hear what the witness has to say, but just because of time constraints. I think that being transparent is always the good approach.
Well, you have to be flexible in cross-examining witnesses, and to a certain extent you have to kind of go where they go. And suppose that under these time constraints, the witness sort of opens up some new area that you hadn't really thought about, but you think, I'm ready for this one, and it's going to expand. Do you jump in and do that, or do you stick to your script? What, David?
Cross-examiners are going to be opportunistic, and if they think that something really potentially beneficial has been opened up unexpectedly, they've got to go with it. You chase the rabbit where he leads you. And you don't get too led astray, but you certainly want to pursue your opportunities when they arise.
So, we'll talk about the scope of cross. Is there any limitation that you've experienced that arbitrators impose on the cross-examination that you can conduct? That is to say, the witness statement covers a certain ground, it says make certain statements. Have you run into situations where the arbitrators say you can only deal with those statements, or you can only deal with the facts that are dealt with there? Or can you go beyond that, or can you even bring up something under those circumstances that of a collateral nature, but that bears on the credibility of the witness? And this witness was, in fact, at another place at another time doing things that show his bias. David, thoughts on that?
Well, my personal predilection would be not to impose very many limits on the scope of a cross-examination. I have seen tribunal chairs on a couple of occasions try to impose limits so that the cross-examination appears to be limited to the four corners of the witness statement, which I find very artificial. I just think that's far too restricted, but occasionally I've seen a chairman do that.
I just interrupt for a second to mention that there was an arbitrator or a practitioner in a seminar a couple of days ago who said that any arbitrator that issues such an order should be taken out and shot.
That would certainly lend some finality to the issue. I think the cross-examiner should be given broad scope. That's the tradition I would come from. And so the opportunity to follow some of the points that, for example, Ben Shepherd outlined at the beginning should be very broad. Are you there to impeach the witness? That isn't usually the case, but if you are, you should be given the chance to do that. If you're there to highlight some of the features of your own case through the mouth of this witness, you should be allowed the chance to do that. Arbitrators will, generally speaking, arbitrators are going to be conscientious. They will have read the witness statement. They'll have some general familiarity with the exhibit bundle. So the cross-examiner has to be conscious of the limits to the tribunal's patience. They're not there to reinvent the wheel or to write War and Peace. They're there to highlight or to impeach or to point out inconsistencies. So it should be fairly crisp and keep moving right along. Don't dwell on something. If you've made the point, move on. And occasionally I've heard chairs say, we think we have your point on that, Mr. So-and-so, after about the sixth question in a row, more or less eliciting the same answer. It's tiresome. So the cross-examiner shouldn't have they should have a good ear for how their whole presentation is going. The scope, in terms of its breadth, I don't think should be artificially limited, but they should also understand they're speaking to a fairly lively audience of 3, and they want to make sure that they get the best out of that.
Sophie, do you put limits on cross-examination in relation to the witness statement, that somehow they shouldn't stray beyond the witness statement?
I mean, unless the parties have themselves agreed that. But even so, I find that, like David, there's a degree of artificiality to it. And if the witness wants to express something that is connected with the statement, and usually it is, because they wouldn't want to say it, I will definitely allow it. I should say, actually, that on all these matters, it is my view that the arbitral tribunal can do a lot to either put a very nervous witness at ease before cross is started by putting it a little introduction, perhaps, introducing ourselves and saying, you know, Mr. or Mrs. So-and-so will ask some questions, and then the tribunal may have questions, and so that the witness has a few minutes to breathe, and then before cross is launched. And if counsel is either being repetitive or appears to put the witness in a position where the tribunal is just not getting the information because the witness is so ill at ease, then again saying, you know, Mr. or Mrs. So-and-so, I think, is asking this, am I getting this right? And then just to sort of, so that the witness understands that it's not so much about putting him or her on the spot, but more about conveying something to the tribunal.
Let me put an example to you. I had a case where there was a witness that was going to talk about the market price of uranium, and it also turned out, as we found out, that she had engaged in certain behind-the-scenes pressuring of one of our witnesses. So I said to the tribunal that I would propose to cross-examine this expert who was supposedly going to talk about the price of uranium, about her pressuring tactics in stopping a witness from testifying. The other side said, no, that's wrong. I said it's right, and the tribunal ruled in my favor, and they withdrew the witness. But so, what about a situation like that? That's something that's quite different. Do you have to announce that in advance, or how do you deal with that? Frank, you've got a thought on that?
I think you need to be. You almost don't want to announce it in advance, because then you lose the surprise of the examination, and the witness may have more of a chance to prepare for it than you wanted to. But you do need to have your arguments lined up, knowing that you're going to get that kind of objection. I think you need to be sensitive to the tribunal. My experience is tribunals view these things as, well, do we think this is important to the case, regardless of where it comes from, or whether it was in a statement or not. And you need to be able to articulate that very clearly when that objection comes that you know is going to come. I think you really need to think about what objections you're likely to get and be prepared to use that as an opportunity to argue your case. Because even if you weren't allowed to give the testimony, you should be able to encapsulate that in what that testimony would show, so that the tribunal gets a flavor for it anyway. Chances are, if you're persuasive and show why this is important, they're going to let you ask the questions, or they may say, well, don't spend a lot of time on it, or something like that. But my experience is that chances are, if you can articulate a good reason to a tribunal as to why they should hear this testimony, they're going to allow it, even if only for curiosity's sake.
Sophie, in my example, what would you have done as an arbitrator?
I think that's a very serious allegation, and I think it's an allegation that cannot, as a matter of fairness, be sprung upon the other side, and so it's no surprise you got the objection. I would have asked the witness to step out of the room, and then I would have asked you to explain why this comes at the last minute and why you think it's important, and then I would have listened to what the other side has to say. And then I would have taken a view as to whether you should, with no more advance notice than that, put your questions. And if I do consider that the question and the matter is important, but the other side keeps saying, no, that's wrong, perhaps I would have asked the questions myself to the witness and brought the witness back in and said, you've heard the allegation, what do you have to say about this? So that it is out, but it is out in a different way.
Are there any situations where the witness from the other side testifies in a limited area and you really want to question this witness on a whole lot of other areas? What do you do about that, George? Do you say, well, I don't have enough time on cross. I want to call him as a hostile witness myself?
Well, I would say that, again, given the time limitations, and I'm avoiding your question a little bit, but given the time limitations, that often isn't the case, because usually I want to focus on the main issues that are presented in the witness statement and the main documents. But I think, given what we've heard from the arbitrators, that I'm to be given a fair amount of latitude, I think I would just plunge ahead. And as a qualification on that, while there may not be a formal limitation that we can only ask about the witness statement, I think, putting aside the extraordinary type of situation you just articulated, that there generally be a limitation that it's going to be limited to documents in the record. And I might self-impose that limitation because I don't want to ask a question I don't know the answer to follow one of Ben's prime rules of cross-examination. So oftentimes it will be the case that the witness statement will be confined to specific statements based upon specific documents, and it's written by the lawyers to make a specific point. But there are other documents in the record that can be usefully used to cross-examine that witness, even though they're not referred to in the witness statement, or even though maybe the specific issue is not referred to in the witness statement.
Frank?
Yeah, I agree that if it's in the record, and I've had the other side try to do this, try to constrain a witness that knows a lot about a lot of things and has their name all over all kinds of documents, and they only have them talk about this limited area and think that they can get away with that. The tribunals, in my experience, will allow you to go into anything in the record that the witness really has some knowledge about, and I think it looks bad on the other side. It looks like a kind of a cheap tactic to try and constrain your witness when you know that they know a whole lot more about the case, and everybody else in the room knows it, and they've got all these documents that have their name on it. I've never had a difficulty going into those kind of areas, as long as they're, substantive and material of the case.
Well, have any of you had any occasion in which you asked a representative of the other side to, you called that person as a witness, required that person testify?
I'm sorry, what was the question?
Have you ever had an occasion where you demanded of the other side that the other side produce a witness in their company or whatever, and that so that you could question him?
We had a recent example, actually fairly dramatic, where there was an issue of attribution in the case. It was an investor-state case, and whether the acts of a certain entity could be attributed to the state. And the main decision maker for the state turned out to have moved on and become a sitting minister of the sovereign. And the other side was sort of trying to have their cake and eat it too, because they submitted a document that consisted of some answers to questions that have been posed by counsel from the witness, but not a witness statement. And they didn't proffer him as a witness. So we went to the tribunal and said, clearly this person, even though he's a sitting minister of the government, is an extremely important witness. And we explained, of course, the reasons why, and his name was on, X number of documents, and he was mentioned 83 times in the memorials, and we really need this person to appear. And the tribunal, in fact, wound up ordering the minister to appear, even though there was no witness statement for him, although they did require that, and this is somewhat obviously contrary to the sort of the spirit of cross-examination, that the witness may not be prepared for the questions you ask, but they required that we outline the areas that we were going to ask him about, and we're limited to those areas. So that was a specific example, and the minister appeared and was questioned and gave very material testimony.
Any other experiences of a similar nature? Frank?
Yeah, I've had experiences where people have the other side has taken essentially a statement or a report written by somebody else and then attached it to either another witness's statement or another expert's report. And so you have this kind of shadow person lurking in the background, and there's usually a balance between, oftentimes instead of asking that the witness be produced, the better tactic is to ask that this evidence be stricken or be removed from the record if we're not allowed to cross-examine, because then it gives the tribunal two options. They can go to the other side and say, well, can you produce that person? And the other side's, if they can, they're kind of like in a difficult spot to say that they really can't. Obviously they do want the evidence. So I think that is a way, and I have gotten behind into those shadow people sometimes, but it's rare that you see that.
No, not really. I think you get almost there when you have someone testifying that he heard someone from like his team in the organization or someone else close to that person saying something, and that's the most that is given in terms of evidence, what we call de relato. No? That's the kind of situation where sometimes you have people saying something, let's say, on behalf of someone else. That's a tricky situation, and then obviously the debate is as to whether this is good testimony or just hearsay or whatever. But my sense is that unless you have extreme examples like this one, where you have some sort of witness statement that you can point at, it's difficult to bring someone in the arbitration as a testimony, and I guess the arbitrators will feel uncomfortable with kind of ordering the appearance of someone who's not really involved in the case unless there is some close link to the parties or a witness statement.
I would add, Larry, I think that would be more usual than not, that I doubt the tribunal in most cases would feel that they should order a party to produce a witness if they haven't elected to do so. The usual response when you have somebody's name all over the place and they're not called is that it's highlighted in argument, and it's sometimes referred to as the empty chair or in some other dramatic way as being a pertinent witness that the party has elected not to call, and you're invited or encouraged to draw an adverse inference from their absence rather than having the tribunal overtly call them as a witness.
I had a case as an arbitrator. I think Steve Hammond was a co-arbitrator in that. We saw a person's name all over the documents. We asked that he be brought in. And both sides told us, after going out ostensibly to investigate, that he was not available, which made us wonder, not quite knowing what inferences to draw from that. Talk about, we all want to confront a witness with a document that contradicts his testimony. That seems to be the gold standard of cross-examination, is to have this kind of successful confrontation. I understand there are some arbitrators who say all cross-examination documents must be disclosed in advance. Have you run into that? Is that something that, as a cross-examiner, of course, you don't want that. Any thoughts on that, George?
Yeah, I actually find that to be a little bit frustrating because I think generally the arbitrations I've been involved in, that has been a rule that there are no such thing as an impeachment document. If you want to use a document at any point during the hearing, it has to be in the hearing record. It has to be a pre-cleared exhibit attached to a memorial or whatever. Now, as Ben said earlier, there may be 5,000 documents in the record, so it takes a lot of flipping over to how do you prepare your witnesses. You have to be really alert to what documents might they get confronted with. But I nevertheless, I do find that the fact that you can't, in effect, spring a witness on a document on a witness and impeach them if they make an inconsistent statement at the hearing is a little bit frustrating. Now, that may be a situation that's akin to the one that you outlined earlier, where you can appeal to the tribunal and say this is a special circumstance. This witness is telling, and get the witness out of the room and have a quote-unquote in-camera discussion. But I do think that has been the rule in most of the most of the arbitrations that I've been involved with, is that if it's not in the record, you can't use it for any purpose, even impeachment.
Frank, do you have that experience?
Generally, and sometimes you'll be allowed to produce essentially additional documents that you intend to use for cross-examination at some point before the hearing, which has become a more usual practice. I do think you face that. In my experience, you usually can't use something that's not in the record, or you can't count on being able to use it. That doesn't mean you don't bring it to the hearing with you and perhaps find a reason to get it in. But I don't think you can go to a hearing unless you've agreed to this in advance, expecting that you're going to be able to cross-examine with documents that are that have not been revealed already. It's relatively rare that you'd be allowed that. You're going to get that objection. If I'm on the side and I see a document, whatever the other side produces, and it doesn't have a record reference, I'm going to be objecting to it immediately. Just on
It's been produced in discovery, but nonetheless hasn't been attached to a memorial or designated as a document that's in support of your case. How in your experience has that been treated?
My experience has been that unless it's actually put in, you're unlikely to be able to use it, at least if you're talking about an international tribunal. There's the idea of discovery is more of an American thing. If you do have Americans, if you have a U.S. judge as your chairman, you can do anything you could do in an American court, probably get away with it. But I think, at least in the tribunals that I've been in front of that are internationally based, they would not view the fact that something had been exchanged by the parties before as a grounds for it being brought into the record at the hearing when it had not been put into the record in the past. At least that's been my experience.
David, what's been your experience?
Well, the general experience and most terms of reference that I've participated in have provided that the record is closed with the conclusion of discovery, and no additional documents may be referred to without leave of the tribunal for good cause being shown in some way. That having been said, I have seen in a few instances where the counsel are aware that they do want to use impeachment documents, and so we've built in some special procedures, such as any document that a party intends to rely on for impeachment purposes must be shown no less than 24 hours before the witness is to be cross-examined. and so there's at least some opportunity for counsel to see them. Don't know, how well that works, but I've seen that in a couple of instances. I agree with Frank's general observation that it would be quite unfair to confront a witness with a document out of the blue that counsel hasn't seen or that hasn't been part of the record in some way or hasn't been disclosed adequately in some way. That would be considered unfair. And I don't think a tribunal would be very impressed with an impeachment on that basis.
You consider as an arbitrator to be unfair,
Yeah.
even though the witness himself was the author of the document.
Well, yes, I probably would. I would say there has to be some reasonable opportunity to look at it, to make sure that it's complete, or that if there's a context to what's been said, that it can be referred to.
Sophie, do you impose a rule like that, or do you care?
I don't impose a rule. I think the process imposes that rule. I have very little patience with springing that sort of tactic on both a witness and the other side. And so I would, if there is that sort of document that has been all of a sudden come to light, again, I would ask counsel to explain why this has not been brought to light before, and if there is a valid reason, I would give some time for the other side and the witness to confront it, limited time, but yes.
What about an expert who's written lots of articles, testified before? Are you saying that should be a requirement that all of those prior articles should be attached to a brief, and because they might be used to question the witness, and maybe even some excerpts from learned treatises that witness might be asked to subscribe to or not? Frank?
Well, the way I usually handle this, typically experts are vain enough to attach their CVs with every single thing they've ever written. And in that case, the way you can usually get into that, and a tribunal will generally allow it in my experience, is first you show them in the record where they have cited this as some kind of authority, and then you'll bring that in, and you might get some objection to it, but if you can show the tribunal at the other side has referenced this or put it in as part of their submission, you're going to get a lot of leeway there. On the other hand, if you had these things earlier and you had a couple rounds of briefing, you may have your own expert on that side actually cite to the other side's article if it's very pertinent in one of their responsive reports, and that would be an easier way to get in. I don't think you're going to surprise any expert with their own writing. They're probably going to have some explanation as to the context to it, so it's not quite the same as having a fact witness who wrote a contradictory memo 2 years ago as having an expert who's written many, many things. And so my experience is usually you're allowed to use it if you can show it somewhere in the record, but the impact of it might not be as large as you might think.
George, what's your experience in this area?
Well, actually, I did have an experience in a Stockholm Chamber of Commerce arbitration where the tribunal, contrary to what Frank was suggesting, wouldn't allow us to cross-examine experts based on their articles if the articles themselves weren't in the record. I think that's extreme, but it happened, and again, it was kind of frustrating.
Well, to be honest, my experience is that, what's in the record